All right. Hello, welcome. I'm watching our number crawl up here as people are joining us. Thank you so much for being here with us today. I'm Lisa from the Law Library, and with me is David Carr, our speaker today. I just have a little bit of housekeeping that I need to go over before I turn things over to David. So thank you for your patience with me while I do that. This is a CLE presentation today, of course, as you know. If you are watching this live, you will be getting a certificate of attendance by email later this afternoon, so be looking out for that. We just need to verify who actually showed up in Zoom. If you are watching this not live on YouTube later, we don't provide certificates for that, but you can use a log that the State Bar provides on their website to keep track of your self-study, and that's what we recommend for that. This is also an interactive presentation where you will be able to ask questions of David. We hope to have plenty of time for questions left over today, as we imagine you might have some on this topic. If you want to post your questions, just use the Q&A function that you see. There's an icon with 2 speech bubbles on your screen. You can post those questions either anonymously or by name, whatever you are comfortable doing. And hopefully David will be able to get to as many of those as possible at the end of the presentation. Also, we will be providing a link to a survey at the end, and if any of you stay a few minutes to take that survey, we would greatly appreciate it. Finally, one extra thing I wanted to talk about a little bit today, something new for 2024 with the Law Library is that we have a new registration system for our classes that I'm sure some of you that are here today have already experienced it. And what does that mean for you? Well, hopefully not a lot. It will look a little bit different when you go in to sign up for the class. You're going to see a different looking screen because you're going to be signing up directly in Zoom, not in Eventbrite. And the benefit of that is going to be hopefully fewer problems with people getting Zoom links. So we're hoping with this change that things run a little bit smoother with the direct registration in Zoom. Another thing you need to know, though, is if you were someone who was following us on Eventbrite, you will no longer be getting notifications of new classes because we're not using Eventbrite. So what I would suggest is that if you want to know about new classes coming up at the Law Library or any events or news about the Law Library, please sign up for our newsletter. It goes out by email weekly, and you can do so on the homepage of our website very easily by just putting in your name and email. I think that's it. And thank you so much for your time. I will turn this over to David.
Thank you so much, Lisa, and good afternoon, lawyers. Thank you for joining me. We're going to spend an hour talking about a topic that's pretty interesting to me, um, and I think it's pretty interesting to a lot of lawyers because it's something new in California, something that we have not had before, and it's something that's pretty controversial. And there are many aspects to it. So we're going to spend an hour, roughly an hour. We're going to go through. We're going to pick apart the new rule of professional conduct 8.3. We're going to pick it apart in detail, talk about each part of it, talk about some of the nuances of it, and then we're going to talk about it's I don't want to say, I guess evil twin might be exaggerating it a little bit, but the companion statute that was enacted, uh, sort of uh, sharing a common genesis in some ways with this rule, uh, that purports to impose a duty to report treason, insurrection, or sedition. And we're going to spend some time talking about that, trying to understand that, which is, in my view, pretty strange. But we'll talk about it. Let me share my screen and we'll get started with our visual aids. There we go. Everybody can see that. The new Snitch rules is what I call this, and the State Bar probably hates. In fact, I know they hate the word snitch because it has a negative connotation. I like the word snitch because it's an attention grabber, and it really, I think, really tells it like it is. These new statutes are statutes that impose a duty on lawyers to report the misconduct of other lawyers. And snitches, stool pigeons, informers, uh, although they are of longstanding uh, we've had this kind of activity for a long time. There's something that strikes many people, and I'll be honest, myself included, as being somewhat unpalatable. The idea that we now have a duty to inform. Some people have said, well, these are police state rules, and maybe that's overstating it a little bit, but there is something about these rules that many people don't like. In the process of enacting these rules, the state bar, of course, the state bar, let me emphasize that, solicited public comment on Rule 8.3. And the interesting thing about the public comment, actually, there were 2 rounds of public comment. Almost all of the commentators were lawyers, not the general public. And of the lawyer commentators, almost a majority of an overwhelming majority of them were negative about the rule, something like 60%. Maybe that's not overwhelming, but that seems to me a pretty large turnout of people that really did not like this rule. But before we, hold on a second. Here we go. Having a little trouble advancing my slide. Let's see. There we go. Let me introduce myself. My name is David Carr. I've been practicing law for 37 years, which kind of astonishes me. It seems like it's gone by really quick, and yet the world of 1986 seems like a strange and alien time. It might as well be 1886. I spent 35 years in the legal ethics space, as we say these days. First working for the State Bar of California as a discipline prosecutor and a manager. And the last 22 years, I've spent in private practice representing lawyers in discipline proceedings, giving lawyers legal advice, and representing proto lawyers in the admission process. So I'm happy to answer any questions. I think this presentation is available as a handout through the law library. If you can't get it through the law library, my email address is at the bottom. I'll be happy to send it to you. Or if you have additional questions about 8.3, not legal advice type questions, but just questions about what the law is, you can email me. Feel free to email me at dccarr, 2 C's and 2 R's at ethics-lawyer.com. So with that, let's talk about let's get into the meat of the presentation. 2 things on our plate today. We have New California Rule of Professional Conduct 8.3, which was effective 8/1/23. In summary, this rule imposes a duty on lawyers to report criminal conduct or serious misconduct by another lawyer. Actually, the phrase uses licensee, so that means a lawyer licensed in California. Criminal conduct or serious misconduct by a California lawyer that raises a substantial question about a lawyer's fitness to practice. That is a capsule summary, but it essentially boils down to either criminal conduct or serious misconduct that raises, again, the test is a substantial question about a lawyer's fitness to practice. Also on our plate, not necessarily the main course, but perhaps as a tasty side dish, we have New California Business and Professions Code section 6090.8, which is a statute, not a rule. And that statute imposes a duty on California lawyers to report another lawyer's participation in sedition, treason, or insurrection, as defined in California and the federal criminal law. So both of these new rules, rule and statute, have an interesting genesis. And so I'd like to talk a little bit about the history. I was a history major, and I understand everything in the context of history still. And I think it's valuable to look at how this came about. Model Rule 8.3 was originally promulgated as part of the American Bar Association Model Rules in 1983. Some of you may be familiar with the ABA Model Rules. Now that we have a California version, and I'll emphasize version of the Model Rules, you may be more familiar with the Model Rules. And maybe like you in law school, you didn't really study California rules. Strangely enough, I went to a good law school, Loyola, and we only talked about the ABA rules. We never talked about the California rule, but most of our attention was devoted to the old Code of Professional Responsibility. Well, that was replaced in 1983 by a new set of rules, ABA rules. Remember, the ABA is a voluntary organization. It's not a governmental body. And when they say model rules, they really do mean models for other states, for jurisdictions that have the real power to enforce them, to adopt. And every state has now, as of 2018, adopted some version of the model rules, but each state's version is different. And there are very significant differences between the states. California, sometimes referred to as the great exception, California, the Golden State, has a very idiosyncratic version of the model rules that reflects California law. After the model rules were adopted in 1983, California revised our own homegrown California rules of professional conduct in 1987-88, but we did not adopt Model Rule 8.3. We adopted some of the language of the model rules, but being California, we had to have our own rules that really went our way. So very little of the model rules made it into the 1987-88 rules. Those rules were effective for 20 years. A lot about the turn of the century. It was felt that after only 12 years, we now needed to completely update our rules of professional conduct. To get an idea of how fast time marches, the original California rules of professional conduct were adopted in 1927, and they had revisions, but they basically stood until 1975 when they were replaced by a new California version. That version lasted 12 years. But even just 12 years after the 1987-88 revision, it was felt there was a necessity for new rules. And part of it was the fact that multi-jurisdictional practice had really taken off. Technology had made geography irrelevant, and lawyers were practicing across state lines in multiple states. And it was thought that California, even though we were always known as the great exception, had to come into step or synchronize a little bit more with the other 49 states. So a commission was formed, and that commission spent 10 years writing a California version of the model rules, which included a version of 8.3. But in the approval process, the former State Bar Board of Governors declined to adopt it for recommendation to the California Supreme Court. In those days, we had a State Bar Board of Governors that was more or less actually elected by the members of the State Bar. That was the era when we were members of the State Bar, not licensees. And we had a Board of Governors, which later became the Board of Trustees. The Supreme Court, after all that work, spent 4 years looking at the work product and decided in 2014 it didn't like it for a lot of reasons, mainly because too much of the language of the ABA model rules that was, I think the term is precatory, was in the draft. In 2014, the California Supreme Court threw the whole thing out and said, well, we want you to go back to the original California concept, that these are discipline rules meant for disciplinary enforcement, not rules meant to offer prophylactic guidance for your conduct, which the ABA model rules in many ways are. These aren't rules that you're supposed to use to figure out what to do. These are only rules that the state bar and the Supreme Court can use to whack you after you fail to do what you're supposed to do. So a second rules revision commission was formed. This commission worked at lightning speed, and in 3 years turned around a second version, California's specific version of the model rules. But the second revision commission declined to adopt Rule 8.3, finding that there was no precedent in California law for it, and that it would be impractical to prosecute. So that was rejected. That was in 2016, 2017. In 2018, the California Supreme Court adopted our California version of the model rules. And it's astonishing to me, but of course I live in the ethics bubble, that there are still lawyers, even 5 years down the road, who are unaware, not only lawyers, but even courts, that seem to be unaware that we have a new and much more expansive version of the rules of professional conduct. I'm always trying to get lawyers to read the rules, and I know that's a challenge because they're over 100 pages long now. But if you're not familiar with the quote new rules, the 5-year-old rules, I encourage you to read them. Maybe read one rule a day until you go through all 100 pages of it with commentary. So as of 2023, some version of Rule 8.3, the mandatory reporting rule, had been adopted by all 49 other states. Some states, of course, with variations. In some states, the duty was phrased as advisory, in keeping with the ABA tradition of telling you what you should do, not necessarily what you'll be punished for. As of 2023, California was the only state that did not have a version of Rule 8.3. Now, what happened to cause this new 8.3 to come about? You can say the word Girardi, but it seems like there's been so much fallout from the Girardi scandal that we keep going back to it. And part of this wave of reform and regulation that has broken like a tidal wave on us over the last couple of years, a large part of it has been due to Mr. Girardi and his theft of, we don't know how much money he stole, maybe at least 20 million. Some people say 100 million. But the Girardi scandal has really been the impetus for a lot of activity. And it's been highly publicized and highly embarrassing to the state bar. In November of 2022, the Los Angeles Times published an article as part of its ongoing coverage of the Girardi scandal, pointing out that California was the only state without some version of 8.3. Now, among the other interesting tidbits of information that's came out in that scandal was that there were lawyers in Girardi's firm, including at least one lawyer. I mean, lawyers who knew about what Girardi was doing, his shell games with the client trust account, his lying to the clients, his misappropriation of funds. And at least one lawyer said, well, I knew what was going on, but I looked at the California rules and I didn't see a duty to report it, so I didn't report it. November 2022, the LA Times publicizes this fact. Within about 2 weeks, the chairman of what is now the State Bar Board of Trustees, we no longer have elected governors, we have trustees appointed by the Supreme Court, stated that California should adopt some version of Rule 8.3. This is really on the ultra fast track compared to prior years. Shortly after December 2022, Senate Bill 42 was introduced by Senator Umberg, should be Umberg, not Umberg. And it provided for a new section 1698 to be added to the BNP code, which would require the reporting of lawyer misconduct. In its wording, to the detriment of the client, and raises a substantial question as to the lawyer's honesty, trustworthiness, fitness to practice, or ability to perform legal services. And second of all, this language about requiring the reporting of lawyers' participation in treason, sedition, or insurrection against the state of California and the United States. I guess kind of a nod to the other another highly newsworthy event that's dominated our lives over the last couple of years, the insurrection that took place at the Capitol on January 6th. So moving with aloricity, which is a fancy way of saying really quick, the State Bar draft that proposed 8.3 submitted it to the Supreme Court in May 2023. And part of the impetus for this quick action was Senate Bill 42. Essentially, what the legislature did was hold a gun to the State Bar's head and said, hey, unless you draft a rule and get it enacted real quick, this Senate Bill 42 is going to impose a rule on you, and it's probably not a rule that you're going to like. So, hurry up and come up with your own rule. And the State Bar did that. The State Bar devoted enormous resources between December and May to drafting, redrafting, soliciting public comment, and getting this before the Supreme Court, all under the pressure of Senate Bill 42. And nobody made any excuses about that. They all acknowledged that was the case. So, sent to the Supreme Court in May 2023, adopted in June. And like I said, almost half, or actually more than half of the public comment, or most of the lawyer comment opposed to it, very little public comment. So let's parse out Rule 8.3. Remember, you can be disciplined for violating this rule. The California rules are all about discipline. At least that's what the Supreme Court told us in 2014. So you really have to know what's required of you. And I can say, having fielded lots of calls from lawyers who are concerned about their reporting requirements, there's a little bit, at least there was a little bit of panic in the air in terms of what has to be reported and what doesn't have to be reported. The good news is the rule itself sets a pretty high bar for what you need to report. It says, without a lawyer, meaning a California lawyer, shall without undue delay inform the State Bar of or a tribunal with jurisdiction to investigate or act upon such misconduct. This section, added by the Supreme Court when it approved the rule, when the lawyer knows of credible evidence that another lawyer has committed a criminal act or has engaged in conduct involving dishonesty, fraud, deceit, reckless or intentional misrepresentation, or misappropriation of funds or property. Pretty serious misconduct. Now, criminal act, of course, could include lots of things. That second to last clause is a little more precise. Dishonesty, fraud, deceit, reckless, intentional misrepresentation, or misappropriation. But the final clause, the capper, at least according to the State Bar folks, and I've attended their programs discussing the rule, say that those subordinate clauses in the middle here are all modified by the overall rule or consideration. It has to be conduct that raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. There's lots of rules of professional conduct, and there's lots of rules of professional conduct you could violate and be disciplined for, or potentially disciplined for, that don't necessarily raise a substantial question as to your honesty, your trustworthiness, or fitness as a lawyer. Although some of the older cases say that every discipline proceeding is about your fitness as a lawyer. In fact, there are a number of rules that are fairly technical in their application. So we really have to look at the conduct when it comes time, when you have to sit down and figure out, do I need to report this to the bar? Your eyes almost have to go to the last clause of the rule first and ask yourself the question, does this raise a substantial question as to this lawyer's honesty, trustworthiness, or fitness to practice? Is it that serious? And that includes criminal conduct. A criminal act that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness. Not jaywalking, although I'm told jaywalking is no longer not a traffic infraction, um, but a criminal act, something that violates the criminal law that raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness. Now that this, part of the whole debate and why we went through many drafts of this rule was the section that says that the lawyer has to know. The lawyer has to know of credible evidence, which, and to know that someone has committed a criminal act, presumably, don't you need to know the criminal law? I mean, the rule almost presumes that every lawyer in the state of California is going to know what the criminal law is. Now, there are going to be instances where, the lawyer has done something that every lawyer would know has violated the criminal law. And many of those things are the same kind of things that are talked about in the last or penultimate subordinate clause: criminal conduct involving dishonesty, fraud, deceit, or reckless or intentional misrepresentation. But minor crimes that don't involve those types of things, under this analysis, looking at the last clause of the rule, are not reportable. So this furnishes some guidance to those of you who have to make a decision. This rule is unlike other rules in that it really imposes a burden on the lawyer to make tough calls sometimes about whether this is something that needs to be reported. And we'll probably get some questions about scenarios that are especially problematical. Well, fortunately, we have the text of the rule, and we parsed it out. We've looked at kind of all the moving parts of the rule itself. But we're lucky because we also have, well, let's go on. There's let's see. Oh, there's other parts of the rule before I get to the comments. I want to get to the comments because they're especially helpful. The second part of the rule says you may, except as required by paragraph A that we just read, you can report, but you're not required to report a violation of the rules. You will always have the option of reporting a violation of the rules of the State Bar Act or rules. Remember, this doesn't seem to leave out criminal conduct, but you've always had the option of reporting misconduct to the State Bar. But now paragraph A makes certain categories mandatory. One of the concerns in the drafting process was out-of-state laws. Other states have laws that California doesn't like, including recent laws that restrict a woman's right to have an abortion. So the third paragraph, subsection C, I think, basically says, well, no, it's only California law you have to worry about. A criminal act in another state, U.S. territory, or foreign jurisdiction, you're not required to report that. If it would not be a criminal act in California, marijuana laws, abortion, things that are crimes in other states that are no longer crimes in California. There's a substantial exception for conduct that you learn while you're participating in a substance use or mental health program, including information that you learn while participating in a program under the Attorney Diversion and Assistance Program. In other words, to encourage lawyers to participate in mental health treatment, substance abuse, rehabilitation, we're going to say that what you learn while participating in that kind of, group meeting, perhaps, if some of you may have participated in the State Bar's Lawyer Assistance Program, you'll know that LAP has a group meeting where modeled on 12-step programs, where you sit around with a bunch of other lawyers and law students, and you kind of do the AA thing where I guess everyone stands up and says, "Hi, I'm David. I'm a lawyer," and then you sort of talk about the challenges you face through mental health issues or substance abuse. what you learn from a co-participant in that kind of setting is not reportable. So there's a very broad exception for that. There's of course a mental health crisis in the legal profession. There's a substance abuse crisis in the legal profession. So we want to encourage lawyers to get treatment. This doesn't affect your obligation to self-report, and I encourage everybody to read section B&P Code section 60680, so you know the self-reporting rules. Failure to self-report where required is a cause for discipline. There's an exception if you're going to seek counsel, if you're going to call an ethics lawyer like me or one of my colleagues, and you talk about the bad stuff you did, I'm not required to report you. Now, there is a similar exception if you are a lawyer operating a state bar ethics hotline. San Diego County Bar Association has an ethics hotline, and people call up with all kinds of problems. We want to encourage lawyers to get advice. So your own counsel, a local bar association, ethics hotline, or similar service, or state bar ethics hotline, what you tell them, we tell people in the county that phrase it as a hypothetical, but what you tell them is not reportable. They can't report it. You presumably, unless it's something you have to self-report, won't report it. Hold on a second. I gotta move a toolbar out of the way to kind of see where we are. Okay. And we're into the comments now. I couldn't see that before. These comments are super helpful to understand the rule. And one of the things that's clarified by comment 3 is that the duty to report without undue delay in the wording of the rule means you are required to report as soon as you reasonably believe reporting will not cause material prejudice and damage to the interest of the client or of the lawyer or a client of the lawyer's firm. In other words, the duty to promptly report means that if there's a reasonable chance that reporting is going to damage your client, and there are many, and probably an infinite number of scenarios where reporting the conduct, say, of another lawyer on your side or opposing counsel, it's possible to conceive of many scenarios where that could be detrimental. That could be detrimental to the client's cause. The state bar generally does not like to be used as a cudgel in civil litigation. So filing state bar complaints to gain advantage in a civil action, you can file a state bar complaint, and many lawyers do, I think unwisely. You can't threaten to file one, of course. But the whole idea is that obviously in sensitive litigation contexts or other contexts, negotiation contexts, reporting a lawyer's misconduct, it may have very detrimental effects on your client. This is a very significant limitation on what you can do. And when you sit down to make the decision to self-report or not self-report, you've got to consider, is this going to prejudice my client? Now, there are references to a bunch of other rules that you should all be familiar with. Again, read one a day until you read them all. 1.4, due to communicate. 1.7, conflict, material limitation. Responsibilities of managerial and supervisory lawyers. And 5.2, the responsibilities of a subordinate lawyer. One context where this whole 8.3 issue is very sensitive, and I've counseled some lawyers on this, is the scenario where an associate of the firm, an employee of the firm, learns of potentially reportable misconduct by a partner or another supervisory lawyer in the firm. And I think you can see that from the point of view of the lawyer employee, that is an extraordinarily difficult place to be. Notwithstanding the failure of the Girardi Keys firm lawyers to report Girardi's misconduct. And you could easily see scenarios where reporting that to the state bar might substantially prejudice or damage the interest of the client, as well as substantially prejudice or damage your employment with the firm. Obviously, if the firm were to fire you for making a self-report, you'd probably have a good wrongful termination claim, I would guess. I'm not an employment lawyer, though I have many clients who are. But it's something that you really have to consider. What are going to be the consequences to the client of reporting this? Now, comment 4 is my favorite, and it's one that has been specifically referenced by the State Bar prosecutors in the Office of Chief Trial Counsel in interpreting the rule. Comment 4 says this rule limits the reporting obligation to offenses that a self-regulating profession must vigorously endeavor to prevent. A measure of judgment is required in complying with the provisions of this rule. No other rule has this qualifier. You've got to exercise judgment, presumably consistent with comment 3. And it also tells us that the question of the term substantial question refers to the seriousness of the conduct and not the amount of evidence you're aware of. The knowledge problem is big here. When do you know? I mean, philosophy, the branch of philosophy called epistemology has debated when do we know something? How do we know something? Or even can we ever really know something for about 2,500 years now? And these philosophical questions are unfortunately permeate a world that depends on your knowledge, although there are other rules that refer to knowledge as well. Comment, I think we're up to comment 5. This repeats the admonition that you're not required to snitch on what you hear in your lab group meeting, or maybe your AA meeting, or other mental health or substance abuse program. I'm sorry this slide is so long, and you really have to read. The comment, I guess, to get the gist of it. When the Supreme Court adopted this rule, the Supreme Court, of course, is the boss, and the boss gets to change the rule. The State Bar may propose a rule to the Supreme Court, but the Supreme Court, has the ability to change it. Their plenary power in the field of attorney misconduct is broad and unlimited, in the words of case law and statute. So they added this comment to guide us for those situations where you're going to report misconduct not to the State Bar, but to a tribunal. And they added this, I think, because they wanted to provide another avenue to report misconduct, probably address misconduct, and say that, well, if you're in a court that has the power to investigate or act on this alleged misconduct, you have to, you may have to determine whether the court is the appropriate place to go to complain, as opposed to the State Bar. And it also definitely says that a report to the court or the tribunal may trigger obligations of the tribunal to report the misconduct, as well constitute compliance, a reasonable remedial measure in the words of Rule 3.3. Yeah, that's comment 7, actually. Or actually, this, I think, is the tail end of comment 6. No, this is comment 7. This is a separate comment. Rule 3.3 is our rule on reporting on candor. And it says that a lawyer that represents a client in a proceeding before a tribunal and who knows that a person intends to engage in fraud, criminal or fraudulent conduct, must take reasonable remedial measures. This is a tricky area because of California's confidentiality statute. But a mandatory reporting, mandatory under Rule 8.3, may constitute compliance with Rule 3.3. The next comment says, in addition, not as a substitute for reporting as required by paragraph A, you may also make a report to another appropriate agency. I don't know who that would be. I guess you could report criminal conduct to a police agency or some kind of administrative misconduct to an administrative agency. Not as a substitute, though, but in addition. You could report it to the state bar and also report it to somebody else. That would presumably not be a mandatory report. And we have this comment that helpfully, comment 9 reminds us. This is something that I still see lawyers do this, and we'll get to a case that involved this in a minute. You can't make an agreement not to report another lawyer's misconduct. Merely making an agreement or even discussing an agreement, even raising the topic of, hey, if we settle this case, we'll agree not to report you. That in and of itself is a cause for discipline under B&P Code 1690.5. And unfortunately, I still see lawyers make these kind of agreements because they're just ignorant of the statute. Don't be ignorant of the statute. You can't agree not to report a lawyer's misconduct. And you can't make an agreement that a client or maybe just a disgruntled client withdraw a state bar complaint as a condition of settlement. The state bar action is independent of any civil remedies they have. And once you file a state bar complaint, it is like an unguided missile. The bar doesn't have to dismiss anybody's complaint, even if they ask the state bar to dismiss it. Remember that communications are privileged, and you can't, tort liability does not attach. There are no libel suits based on state bar complaints. But a false or malicious complaint can lead to discipline or other penalties. So that's a quick tour through the comments. And I really recommend, again, if you get the slides, I got the text of the rules here and the comments. You got to read the rules more than once. I read them all the time, over and over again, even after 35 years. But if you're faced with the difficult decision about reporting misconduct, you're going to have to probably read the statute more than once, and you may have to get some kind of advice as to whether you need to report. One issue that's come up, Rule 8.3 was effective on August 1st, 2023. And the state bar has taken the position that because knowledge of the misconduct is the triggering event, OCTC, the Office of Chief Trial Counsel, has taken the position that, well, on August 1st, 2023, if you knew about something that took place in the past, as of August 1st, 2023, you have an obligation to report that, even if it occurred before the effective date of the rule. And this obviously raises issues. What about, I'm going to give a real life example. In one of these seminars, I can tell you for a fact that I know of lawyer misconduct that occurred in the year 1988 when I was a young lawyer. It's just before I went to work for the state bar. I know of lawyers who committed misconduct reportable under 8.3 that occurred 36 years ago. Do I have to report it now? I asked that question of the Chief Trial Counsel, Mr. Cardona. Mr. Cardona, interestingly enough, served on the Signet Rules Revision Commission and was one of the commissioners that voted against adopting a version of 8.3 in 2016. Now he finds himself saddled with the job of potentially enforcing it. And when I raised that question, the Chief Trial Counsel referred me to Rule 4 and said that, which cautions us that making the decision to comply with this rule requires the exercise, of judgment, the exercise of judgment. So even though, strangely enough, the bar takes the position you have to report misconduct that occurred maybe even decades ago, uh, you have to exercise a measure of judgment in making that decision. The problem is, since these are discipline rules and you potentially can be disciplined for not self-reporting, exactly how do you exercise that judgment? I mean, it's kind of like, imagine there was a criminal statute. It said, well, you can't do this certain thing. But if you do it, you have to exercise a certain measure of judgment. Um, the problem is it really leaves things wide open for, I mean, it's really hard to know exactly where to draw the lines when it comes to misconduct. How far back in the past? A year, 2 years, 2 days, 3 days? Taking the position that you're required to report things that happened before the effective date of the statute really confuses things. And when you combine this with the problem of knowledge, when do you know something happened, especially with regard to criminal acts? Some things I mean, again, there's always going to be a gray area. There are things you don't know, things you do know, and then a gray area where you don't know whether you know or not, whether there's conduct that violated 8.3. You can see the practical problems in prosecuting a lawyer for not self-reporting. The practical problems that led Mr. Cardona and the other members of the Second Rules Revision Commission to decline to adopt it. There's not much case law in the other jurisdictions that have adopted Rule 8.3. There's not much case law. There's a handful of cases, but by and large, the other 49 states, with some exceptions, have not been active in prosecuting this rule. One case that came up very early after Rule 8.3 was adopted, although it really interprets an earlier rule, is In re Himl. And In re Himl is often cited as kind of the most important touchstone case on the duty to report misconduct. And it has some interesting aspects. In this case, client Forsberg hired attorney Casey to represent her. Forsberg stole the settlement, put the money in his client trust account, and then just took it. Forsberg then hires attorney Himl to try to recover the money. Himl had learned that Casey had stolen the settlement. Himl did not report Casey to the Illinois Discipline Agency. It was required by the Illinois rule. Instead, employed on a contingent fee, he negotiated a $75,000 settlement with Casey, including a term in the agreement where Forsberg agreed not to initiate civil, criminal, or attorney disciplinary action against Casey. It really almost looks like that was bargained for. You know, Casey stole $35,000. The client share was something like $22,000. Himl negotiates a deal that says, we won't report you, but you got to pay $75,000. Well, Casey defaulted on the agreement. Himl filed an action and received $100,000 judgment against Casey on behalf of Forsberg. We don't know if it was ever paid. And Himl was prosecuted by the Illinois disciplinary authorities, the ARDC, they called them back there, for not reporting Casey. Himl said, well, number one, my client told me not to report, and not a defense. And second of all, well, my client had actually herself reported Casey to the disciplinary authority. The Supreme said, no, that's not a defense either. And noting two things, that Himl appeared to have negotiated this agreement, which gave him a substantial benefit, and that Casey went on afterward to steal money from other clients. It suspended Himl for 1 year. So here's an example of Rule 8.3 in action, and maybe an extreme example, but there aren't many real life case examples. We don't know how long we'll have to wait in California to get one. Maybe years, maybe never. Will the state bar ever prosecute a Rule 8.3 violation? Maybe not, maybe never. Well, let's turn to the other thing that's on our plate. As part of the original SB 42, this was in the original bill. After the Rule 8.3 was adopted, the first part was taken out, but this stayed in. And it says a licensee who has knowledge that another licensee, again, a State Bar California lawyer, has engaged in any of the following crimes, knowledge of crime. Obviously, you have to know what the crime is, right? Seditious conspiracy, treason, rebellion. You got to report that to the State Bar. Well, what are the definitions? When you look at the statutes, I mean, they're not very helpful in defining it. Seditious conspiracy, conspiracy to overthrow, put down, destroy by force the government. Levy war against them, meaning the United States. Opposed by force, or by force to seize, take, or possess any property of the U.S. Some of the January 1 defendants have been, I think, prosecuted for seditious conspiracy. Treason, good old treason, which we hear bandied about quite a bit now. Whoever shall, owing allegiance to the United States, levies war, adheres to their evidence, that's a nice word, giving them aid or comfort within the United States and elsewhere, capital offense. Now, California Penal Code 37 has the same concept in our state. You can commit treason against the state of California, apparently. And they also incorporate the nice nifty part of the Constitution that requires 2 witnesses. Again, life imprisonment or death without possibility of parole. Insurrection. Now, this definition is even, I think, less helpful. Incites, sets on foot, assists, or engages in any rebellion or insurrection against the authority of the United States shall be fined. So we have these statutory criminal definitions, and presumably you're going to have to know it when you see it, because knowledge means actual knowledge. And even though you can maybe infer from circumstances, the way this differs is it's not constructive knowledge. You have to have an actual sense impression, to use a philosophical term, a sense impression of something that constitutes insurrection, sedition, or treason. And again, you're not required to report it if it requires disclosure by the attorney in a substance or mental health program operated by the State Bar. Knowledge is similar to the actual knowledge prong is similar to the rule of professional conduct. And you can't harass somebody. You can't make a false State Bar complaint saying this lawyer engaged in insurrection. Now, the funny thing is, we're not sure if this section is self-executing or not, because there's this section that says the board may amend the rules to provide for it. So we may see an amendment to Rule 8.3 to incorporate this. But it's not totally without precedent. In 1951, at the height of the post-World War II Red Scare, and so, the other one as opposed to the post-World War I Red Scare, we adopted this statute that advocating the overthrow of the government constitutes a cause for suspension or disbarment. So it's not totally without precedent, but again, we're in a strange historical era like 1951, and we have this interesting new statute to contend with. So I hope I've left enough time for questions. So let's see what the questions are. I see 8 questions. Wow.
Yes, we do have a few. I've been busy typing, answering a few that were really just about some nuts and bolts and the CLE certificate.
Okay.
Just want to let everybody know you don't need to do anything to check in with us to prove that you were here. If you're here listening and we're able to type into the Q&A, you will be on the attendance list that's automatically generated by Zoom. So no worries about that. And if anyone has any issues, just let me know. You can get me at lfoster@sdlawlibrary.org by email. So, but that shouldn't be a problem for anyone who's here and actually listening. So let's get to a few of the questions. We have one from Sergey. He's asking basically for you to comment on the conflict or potential conflict between the First Amendment and this snitch rule. Does membership in the state bar preempt these rights of silence due to voluntary membership? I
Well,
believe there's a body, there's probably case law, isn't there, David, already kind of litigating the constitutionality of our rules of professional conduct?
well, they've always been upheld so far, and I'm not sure if the question refers to the Fifth Amendment, which
Yeah,
is your
I
right
think
not
so.
to implicate yourself. Uh, I, considering, and I guess the second part of the question is, should the attorney report on criminal conduct with expired statutes of limitation? There's no statute of limitation in the rule. So presumably, even if the statute, again, this is the problem of conduct that occurred years ago. Do you have to report it? And again, a measure of judgment. If the statutes of limitation have expired, maybe the exercise of judgment says you don't repeat it. But again, the measuring stick has to be, is this conduct that reflects on the lawyer's trustworthiness, honesty, or fitness to practice? And I think that's got to be that. And the exercise of judgment says, does this conduct reflect on this lawyer's current trustworthiness, honesty, or fitness to practice? Reporting a lawyer for a dishonest act 30 years ago seems kind of pointless. So maybe statutes of limitation might play a role in the exercise of that judgment. But there's no limitation on statutes, incorporating statutes of limitations.
All right, here's another one. Hypothetical. I know that a lawyer is cheating on his spouse. He routinely lies to his spouse about where he is, what he's doing. Let's assume he uses community property to pay for hotel rooms. Oh my. That conduct involves dishonesty and deceit. Does that raise a substantial question as to the lawyer's honesty or trustworthiness? Do we trust a lawyer who's selectively a liar?
In my view, because the state bar has always punished dishonest conduct, whether or not it occurs in the practice of law, the duty of honesty is considered so integral to the duties of a lawyer that even dishonesty not directly related to the practice of law, it can be punished and punished with substantial discipline. So my guess is, yeah, that kind of conduct is probably conduct that you at least have to consider whether you should make a mandatory report of that conduct. Again, if the context of this is a marital dissolution case where where you represent the other spouse, you've got to really consider, how is this going to affect my client's rights if we make this report? And is it going to have a detrimental effect on our ability to make this marital dissolution work? In the family law practice, lawyers are always, it's kind of like an arms race sometimes, where I see so many state bar complaints that involve allegations of misconduct, ethical misconduct, that they're made, I think, mostly just in the interest of throwing every possible weapon at the other side. So this is a prime example where consideration of the client's interests and an exercise of judgment as to whether making this self-report is in the client's interest really has to be carefully examined. I mean, but on its face, it's dishonest conduct that, if the bar could prove it by clear and convincing evidence, it would certainly be disciplined or disciplinable.
And we're quickly running out of time, but I kind of want to skip over to another question that sort of relates to what you were just saying, David, which is the question basically, how is this working in the other 49 states? Do we see mandatory reports with colorable merits made against opponent for leverage out of spite? Or do we see lawyers really disciplined for failure to report a mandatory situation?
We see very little activity. I've discussed this with my out-of-state colleagues. We see very few. This rule is not widely enforced because of the impact on the client's interest, because the exception for confidentiality. You don't have to report confidential client information protected by 1.6. The other states really do not enforce this rule, and my guess is that at the end of the day, there's going to be very little California enforcement activity. But the rule is still there hanging over our head. And to me, this is almost what I like to call an interorum rule. It may never result in discipline, but it's always going to be out there as a reminder that if something like the Girardi case happens, it will probably be enforced. But yeah, you've always, and interim for the reporting attorney as well as the attorney that commits misconduct, knowing now, well, if I commit misconduct and some other lawyer learns about it, I could be reported. So discipline there may not be a lot of disciplinary activity, but it's certainly going to change the atmosphere. And it very much could, as one questioner raised, kind of have a civility impact. We're talking about trust and civility in the profession. Imposing a duty to snitch, how is that going to work in terms of keeping us civil and trusting of our colleagues? It's going to probably have a negative effect.
Yeah, and I think that goes to Joni's comment that I'm seeing here, to the same thing, that some concern that the new rules are going to create a negative atmosphere. So I think you answered that one. So we are at 1 o'clock. For anyone who has to run along, please feel free. You really don't have to post in the comments to get the CLE, so I didn't want to create any misunderstanding about that. For those of you that are posting just to be seen, I will see your name on the attendance list automatically if you're here. Did you have time for any more questions, David, for anyone who wants to stick around a couple minutes?
I see one question from someone I know who says, "Do you see positive aspects to the rule?" Well, it probably will deter misconduct. Again, that interim effect is probably going to deter misconduct. There's probably, whether it's ever, whether it results in discipline or not, it's out there, it's hanging over our heads, and certainly it's been highly publicized. So yeah, it may have it may have some positive effects.
So how about a Himl hypo that someone has posted here regarding the Himl case? Himl reports Casey, client loses the ability to recover any of the stolen funds. Would client have a malpractice claim against Himl?
I don't know. The client got $100,000 judgment against Casey, so I'm not sure there would be I'm not sure there would be a claim against Himl. I don't know. I don't really do legal malpractice.
Yeah. So yeah, different subject matter. One final question, I think, here.
Yeah, this is a good one. Knowledge of violation of a civil harassment TRO, which led to another attorney being taken into custody overnight. Is reporting required? I don't know. That's something that's got to be examined. Again, violation of a civil harassment TRO, does that necessarily involve conduct that reflects on trustworthiness, honesty, or fitness to practice? Not necessarily. I mean, I've seen lots of TRO cases where where the TRO is violated for lots of different reasons. So I don't think it necessarily would. Though you might be able to construct hypotheticals where it would, depending on exactly what the violation was.
Yeah, that's what I was thinking too, maybe dependent on the context there. So one final comment here, the biggest problem I see is that I always take the high road and this prevents it. Yeah, I can see where this person's coming from.
Yeah, and I think that's a very good observation. And it's worth knowing that who regulates the legal profession? It's regulated here and in here by and large. And the rules are only floors, they're not ceilings. They are minimum standards below which you shall not fall on pain of discipline. But in practice, you should aspire for something more than minimum standards, in my view.
Okay. Seems like a good note to end on. Thank you so much, David, and thank you for everyone who stuck around with us and attended today. Be looking out in your email for your CLE certificates.
Thanks again.